Hello, good afternoon, everyone. Thank you very much for joining this webinar. My name is Tian and I'm a disputes lawyer at Clifford Chance Asia, and I will be your MC for this event this afternoon. With me is my colleague Yvette Anthony, counsel at Osborne Clark, and we are also very delighted to have with us today three distinguished guests. Ms. Hazel Tang from the ICC, Mr. Colin Liew, independent advocate with Essex Court Chambers Duxton, and Ms. Eunice Chua, who is the CEO of the Financial Industry Disputes Resolution Center. So thank you very much for joining this webinar organized by the SBF and the International Chamber of Commerce. Let me now give a brief introduction on the format of the event, and this is what we have lined up for you this afternoon. So we'll first invite the SBF to say a few words, and this will be followed by an opening speech by Hazel from the ICC. And thereafter, Colin and Eunice will share their thoughts and insights about the legal implications of the COVID-19 pandemic, as well as how mediation and ICC arbitration can be useful as mechanisms for the efficient resolution of disputes arising as a result of business disruptions due to COVID. And the last section of the event will be a Q&A session moderated by my colleague Yvette. And I believe we have invited some of you to send in questions. And of course, if anything further comes up, please feel free to use this Q&A function on Zoom to raise your queries, and we'll try our very best to address your questions. Please also take note that this session will be recorded and uploaded onto the SBF's website. Now I'll hand over the time to the SBF. Mr. Jason Lee, Deputy Director of International Relations at the SBF, will give his opening remarks. Jason, please.
Thank you, Tian. Very good afternoon to our speakers, Ms. Hazel Tang, Mr. Colin Liew, Ms. Eunice Chua, and also to our members joining us today on this issue of commercial and legal disputes arising from the COVID-19 pandemic. My name is Jason Lee, and I'm in charge of international relations at the Singapore Business Federation. Today's webinar is part of a series we've organized over the past few months, while most of us are forced to work remotely and physical events are prohibited. We have brought to you private sector experts and key public officials to discuss issues businesses face as a result of COVID-19. From building resilient supply chain models to taking advantages of opportunities in the digital economy. And these are on top of running some of our usual courses on free trade agreements and global trade developments online. We are, fingers crossed, starting to see the light at the end of the tunnel as restrictions are gradually lifted in Singapore. While we all hope that businesses can resume operations and markets recover soon, the impact of COVID-19 is expected to have a long tail. Commercial disputes are one such aspect. The ability of many businesses to meet previously envisaged obligations have been seriously impacted. And while regulation has been enacted in Singapore to address some scenarios, it is not always clear-cut in other cases. And if foreign jurisdictions are involved, it may be even more complicated. So we are very glad to have with us today legal experts and arbitrators who will share with us what to do, the options available, and possible recourse should businesses find themselves in a commercial dispute. A big thank you to our speakers for your time and effort in preparing today's presentations, and also to the ICC Singapore Arbitration Group Business Outreach Committee for steering this and making this event possible. SBF supports the work of ICC Singapore Arbitration Group in promoting arbitration and alternative dispute resolution services, and acts as its secretariat by managing the database of arbitrators and coordinating the nomination of arbitrators. If you're interested to find out more about the group and its activities, please feel free to email us at iccsingapore@sbf.org.sg. Well, now, without further ado, let me hand over the time to our first speaker, Hazel.
Thank you very much, Jason, and good afternoon to everyone, or good morning, wherever you're dialing in from. It is not the strongest of the species that survives, nor the most intelligent that survives. It is the one that is most adaptable to change. A quote that is often credited to Darwin in his Origin of Species and his theory of evolution. But according to the Darwin Correspondence Project conducted by the University of Cambridge, really came from a management studies text. Its questionable source aside, this quote to me really captures the essence of what one must do during these times that we are facing right now. The COVID-19 pandemic has undeniably impacted us on many fronts. Virtual hearings are becoming increasingly common in our arbitration cases, involving amounts in the dispute ranging from tens of thousands of dollars to billions of dollars. Even from the institutional perspective, the ICC court sessions have been moved entirely online, starting from March 2020 this year. As of July, we have held over 50 court sessions remotely, which are attended by over 50 participants from all around the world on average. The search for a solution that responds to businesses' needs to resolve disputes efficiently has always been ongoing, even before this, but has become more urgent now. Particularly in light of entire countries' lockdowns around the world, travel control measures, or even postal services disruptions, and other uncertainties looming on the horizon, we too have to adapt. The conversations relating to the increased use of technology in the way we manage our disputes and also in our businesses, such as e-discovery, or simply adopt a cloud-based documentation system within companies. And the move away from the traditional way in which things were done are all now being drawn into the spotlight. On the business front, especially, the disruptions arising from the COVID-19 pandemic have impacted parties' cash flow or the ability to perform existing contractual obligations. We have seen many more requests for extensions of time to either make submissions of payment, citing COVID-19 as a reason without more, as if this is a vibranium shield that can protect one from any and all legal obligations. Would this really relieve one of contractual obligations? Well, about different countries and their own reactions. As you know, Singapore has legislated the COVID-19 Temporary Measures Act on 6th of June 2020 to provide temporary measures and deal with other matters relating to the COVID-19 pandemic. How does this interplay with parties' own contractual obligations, or with the concept of frustration of contracts or force majeure clauses? And what about exploring mutually acceptable solutions through the combined use of ADR options like mediation? A lot of parties were already dipping their toes into the waters of online dispute resolution for mediation before the COVID-19 pandemic. Is this the way to go moving forward? The good news, for me at least, is that in delivering the opening remarks for this seminar, I need only to ask the questions. The learned speakers that I see we have lined up in this seminar will have the arduous task of giving you the answers to your questions. And with that, I gladly hand the spotlight over to the speakers for today and wish everyone an interesting discussion ahead and to stay not only safe, but positive during these challenging times. And I would like to leave you with a quote of my own. For the only uncertainty in life is the uncertainty of life, and adapt we will, as we always have been, and will emerge from this the stronger and better. Have a good seminar ahead, and thank you for your attention.
Thank you very much, Hazel, for the very insightful opening speech. And before we start with the substantive presentations, we thought it'd be good to get everyone started by doing a very quick poll to get a sense of what your general views are on arbitration and mediation as a means of dispute resolution. So with that, maybe I can invite Nisa to start the poll. So now on screen, you will see a polling window. grateful if you could just have a quick think about this and put in your intuitive answers. Okay, and maybe we can close the poll at this point. Interesting.
Yes, those are certainly very interesting results. And I think some food for thought for our panelists will be whether or not these results are unique to the COVID-19 situation or whether they are demonstrative of a long-standing trend. And I think that is something that we can leave for further down in the session. And back to Tian to take the program forward.
Thank you very much, Yvette. And now we'll move into the substantive presentations. We'll start by inviting Colin to say a few words about the legal implications and disruptions caused by the COVID pandemic, and to address some of your burning questions on the legal doctrines of frustration, force majeure, as well as the COVID-19 Temporary Measures Act enacted in Singapore to provide temporary relief to affected businesses. So Colin is an independent advocate with Essex Court Chambers Duxton, and he specializes in commercial arbitration and litigation. He has argued a number of reported cases in Singapore involving novel and important points of law, and is consistently recognized in the legal directories as one of Singapore's leading lawyers. And we're very privileged to have him with us this afternoon. Colin, please.
Thank you very much, Tian. And it is my very great pleasure to be here this afternoon, courtesy of the SPF and ICC, and what I think is a wonderful initiative for its members. I'm going to share my screen because I prepared a couple of slides that will hopefully help our attendees follow what I will be saying. So this afternoon, I'm going to touch on three broad topics. The first two are substantive in nature, covering the doctrine of frustration and the issue of force majeure clauses, which of course is very, very fashionable these days. And I will also touch very briefly on the COVID-19 Temporary Measures Act, which is a very large and complex piece of legislation. So I can't cover all the aspects of it in detail today. I will just focus on one specific part that is, I think, a little bit more related to frustration and force majeure, and might be of a little bit more interest and relevance to today's attendees. Then I'm going to hand over to Eunice, who will talk about mediation. Before I round up the discussion about arbitration and discuss some of the rules of ICC arbitration, which are particularly well suited, I think, in this climate for dealing with disputes, COVID-19 related disputes. So can I just start with frustration? That, as many people know, is a legal doctrine that discharges a contract in its entirety and excuses the parties to the contract from further performance. And obviously what it requires is a frustrating event, which has to be unforeseen. It cannot be the fault of either party, because if it is, then that's basically a breach of contract by that party. And the frustrating event, must render contractual performance either impossible, literally impossible, or radically different from what was contemplated by the parties. Now, although frustration is sort of at the tips of everybody's tongues these days as to whether COVID-19 is a frustrating event and whether we'll see lots of frustration cases on the horizon, frustration does require a very high threshold before it can be invoked. It is highly exceptional, and it is not it cannot be successfully invoked merely because of the additional hardship or the extra costs involved in performing the contract. It really has to be something that affects obligations that are fundamental and that go to the root of the contract before a court or tribunal would be prepared to accept that the contract has been frustrated. So some of the examples, historical examples that we've seen of frustrating events. For instance, a couple of years ago, Indonesia imposed a ban on the exports of sand to Singapore. And this was a huge shock to the construction industry in Singapore. And there were a number of reported cases arising from the sand ban. And the courts were generally prepared to hold that the sand ban was indeed a frustrating event, which frustrated contracts for the supply, for instance, of ready-mixed concrete. Similarly, compulsory acquisitions of land, whether by the Singapore government or foreign government, will or have been held to frustrate contracts for the sale of that land. Similarly, wartime invasions have been held to frustrate contracts which contemplated delivery of machinery or products to the country that was invaded. So these are, as you can see, wholly sort of exceptional situations and circumstances that are well beyond the contemplation of the parties, but which affect in a very fundamental and intrinsic way the performance of the contract. So of course, questions will arise as to whether COVID-19 or the measures that various governments have taken in light of COVID-19, whether that amounts to a frustrating event. And it's very difficult, I think, to give an answer in the abstract. Obviously, COVID-19 and the antecedent consequences affect different contracts and different industries in different ways. And so it may well be a frustrating event in some types of contracts, perhaps, for instance, construction contracts where it was contemplated that construction could take place over the period where quarantine measures were in effect. That could amount to a frustrating event as far as the contract is concerned. What then are the consequences of frustration? And that's governed in Singapore, at least, by the Frustrated Contracts Act. And you will see a couple of sections on your screen as to what the Act provides. For instance, the Act, and therefore the doctrine of frustration, will only apply where there is no contractual provision which governs the situation. So if you had, for instance, a force majeure clause, that might well exclude the application of frustration and the Frustrated Contracts Act. Parts of the contract that have already been wholly performed by the time the frustrating event occurred might be held to have already been wholly performed and therefore not affected by the frustrating event. And so the contract might be severed in that respect. Historically, the Frustrated Contracts Act has not applied to certain types of contracts, typically shipping contracts. That historical exemption has been preserved in the Frustrated Contracts Act. Where a contract is frustrated because the contract as a whole is discharged, that usually means that both parties will have to give restitution of sums paid. There may be credits or allowances given for expenses incurred or benefits received. And on the whole, the court or the tribunal tries to adjust the obligations of the parties such that a fair result is achieved at the end of the day. It must be said that there's not a great deal of case law on how the Frustrated Contracts Act works, precisely because frustration is such a exceptional doctrine that it is very rarely successfully invoked. So there is limited guidance, I'd say, as to exactly how this sort of restitution and credit being given for benefits received works in the real world. Can I then just quickly move on to force majeure, which is, contrary to popular belief, not a legal doctrine as such. It's not a rule of law. What it is that it's a specific type of contractual provision which parties agree to insert into their contracts. And the clause, the force majeure clause, will specify circumstances under which one or both parties are excused from performance. So, like frustration, what a force majeure clause typically requires is a force majeure event that is beyond the party's control and which prevents, or hinders, or impedes the party's performance. And that is usually sort of boilerplate language that you will find in a force majeure clause. The clause will generally also require the affected party to have taken reasonable steps to avoid or mitigating the event or its consequences. And to the extent that the party has not done so, he may not be able to rely on the force majeure clause, and indeed he may be in breach of contract as a result. So the types of force majeure events that you generally see in a force majeure clause are divided into political force majeure events like war or invasion, or not natural force majeure events such as act of God, natural disasters, that sort of thing. So a typical example is paragraph 3 of the ICC force majeure clause. And you'll see there a sort of laundry list of force majeure events covering everything from war to strikes and lockouts. So that, for instance, is a commonly seen type of force majeure clause. And I just draw your attention to epidemic here in the third line, which again is typically seen in force majeure clauses. And obviously will be very, very helpful if there is a force majeure dispute about COVID-19, for instance. It would probably be a lot easier to establish that COVID-19 is a force majeure event if your force majeure clause specifically referred to an epidemic or a pandemic. If it didn't refer to an epidemic or pandemic, then I think there would be a dispute as to whether or not parties truly intended for the COVID-19 epidemic to constitute a force majeure event. There are real similarities, I think, between frustration and force majeure, but there are real differences as well. So, for instance, force majeure can only be invoked if you've got a force majeure clause. If you haven't got a force majeure clause, then there's really no force majeure to talk about, right? You're really in the realm of frustration, because frustration, being a general legal doctrine, can in theory always be invoked. But like I said, as the Frustrated Contracts Act shows, the doctrine of frustration can expressly or impliedly be excluded, for instance, by a force majeure clause. Force majeure clauses usually have notice and time bar requirements. So the clause will usually say you've got to serve a force majeure notice on the counterparty if you're trying to invoke the force majeure clause. There will be time limits as to when you can do that. If you successfully invoke frustration, the doctrine of frustration, the consequences are different. The entire contract is discharged, except for those parts of the contract which have been fully performed. By contrast, the force majeure clause will normally provide only temporary relief. And if the force majeure event stretches beyond that period, then the contract will usually provide that the parties have an option to renegotiate or terminate the contract. And then finally, force majeure clauses, because they are ultimately contractual clauses, they are technically negotiable. Parties can agree as to what force majeure events they want to put in, what the sort of consequences are. But like you saw in the ICC clause, generally the force majeure clause will be in standard form, and like a lot of ancillary clauses like arbitration clauses, they are typically in standard form, and there usually isn't a great deal of negotiation over the wording of the force majeure clause. But I suspect, in light of the COVID-19 situation, parties will now start to pay a lot more attention to exactly how the force majeure clauses are worded. So I think we'll see a lot more attention being given to the corporate lawyers to force majeure clauses. Now, obviously Singapore has passed the COVID-19 Temporary Measures Act, and a big question on a lot of people's minds is exactly how does the Act relate to the doctrine of frustration or existing clauses in the existing force majeure clauses in the contract. Before I get on to that, can I just explain how the Act works? There are, as I said, the Act is a large piece of legislation, and it seeks to introduce temporary measures to do 5 main things. First, suspend contractual obligations for certain types of contracts which have been set out in the schedule to the legislation, and that's what I'm going to be focusing on today. Second, to provide relief from financial distress to individuals and companies. Third and fourth, to introduce alternative arrangements for company meetings and court hearings, which would otherwise have had to be conducted in person. And the legislation provides, obviously, measures for all of that to be done remotely. And finally, to introduce measures to restrict public activities to prevent the spread of COVID-19, which is what we've been living under for the past 3 months. But just concentrating, first of all, on the first broad aim of the legislation, which is to suspend certain types of contractual obligations. There are 5 categories of scheduled contracts in the legislation. The first is secured loans by banks and finance companies to Singapore small and medium enterprises, and there's a specific definition of SMEs in the legislation. The second category is construction or supply contracts or related performance bonds. Third, event or tourism related contracts. Fourth, hire purchase agreements for commercial plant, machinery, or vehicles. And the fifth, leases or licenses of non-residential property. The scheduled contracts have to have been entered into before the 25th of March 2020, and they must be performed on or after 1st February 2020, these being the dates when Singapore felt the full brunt, I think, of COVID-19 and the lockdown measures. There must be an inability to perform the scheduled contract due to a COVID-19 event, and that's defined as the pandemic itself, or the operation or compliance with any local or foreign law or order made by reason of or in connection with the pandemic. In other words, things like quarantines, lockdowns, and other measures that various governments around the world have introduced that have disrupted supply chains internationally. Because the legislation is called the Temporary Measures Act, the prescribed period for relief is only a period of 6 months for the time being, although that can be extended to a year by ministerial order. So exactly how does it work? So let's say you have defaulted under scheduled contract because of the pandemic or because of the lockdown, and you want to try and obtain relief under the Act. What you've got to do is you've got to serve something called a notification for relief on the other party and any sureties, setting out the obligation to be performed, how the inability to perform was caused by the COVID-19 event, and any proposed alternative solution. Once that is done, the counterparty or the party on whom the notification is served is prohibited from effectively enforcing his contractual rights. So this is quite a drastic and unprecedented interference with contractual rights. The counterparty is effectively prohibited from starting any court or domestic arbitration or insolvency proceedings, enforcing security, enforcing judgments, terminating the lease or license, repossessing the goods, and so on. Just pausing there, can I just stress that the party on whom the notification is served is prohibited from starting or continuing court proceedings or domestic arbitration proceedings. But the Act doesn't apply to international arbitration proceedings. With good reason, obviously, Singapore has no real interest in legislating to interfere with contractual rights with foreign parties or foreign domicile parties. So if you've entered into any sort of scheduled contract with a foreign party, the Temporary Measures Act may not be particularly helpful because the foreign party, there's nothing to stop the foreign party from starting international arbitration proceedings. And Hazel might join us a little later to say something about whether or not the ICC has seen any sorts of disputes in relation to this regard. Now, the prohibitions are not just for show. I mean, they're backed up by real consequences. If the party on whom the notification is served disregards the prohibitions. Any lawsuit or domestic arbitration will be summarily dismissed. Any other prohibited actions, like an attempt to enforce security and so on, will be void or invalid, and there are criminal penalties. But obviously, to protect the interests of the party who is prohibited from enforcing his contractual rights, the Act does extend applicable limitation periods that might otherwise run during the prescribed period. Now, finally, before I hand over to Eunice, I just want to discuss a little briefly what happens when there's a dispute under the Act. And the sort of disputes being envisioned, basically whether or not the Act even applies. Has there been a COVID-19 event? Was the inability to perform actually caused by the COVID-19 event? The legislation provides that these sorts of disputes are not to be determined by a court, but by what are known as assessors appointed under the Act, who will try to achieve just and equitable outcomes. For instance, whether or not any part of a deposit ought to be refunded or forfeited. And because this is not being determined by a court or judicial body, this is really not intended to be a formal legal process as such. It's all done by way of emails, generally. Parties cannot be legally represented before the assessor. The assessor's determination is final and non-appealable. So all of this is pretty unprecedented, I'd say. I mean, essentially, these are parties' legal rights and obligations being determined in a non-legal manner. But obviously, the pandemic is an unprecedented situation. And the trade-off is that this assessment process is free, and there are no costs that are incurred by either party or awarded to either party. So it's meant to be a very quick, clean, hopefully painless affair for both sides, who can get this over and done with and try and get on with their rights and obligations as quickly and as efficiently as possible without wasting time as they ordinarily would in court disputes, and which might tie them up for, months or years. Now, finally, just circling back to what the relationship is between the Temporary Measures Act and frustration and force majeure. That's set out in the Act itself. The Act does not affect the taking of any other action in relation to the inability to perform a scheduled contract, including an action pursuant to the Frustrated Contracts Act or a force majeure clause. So for instance, what that means is that if you've got a force majeure clause in the contract, then really the Temporary Measures Act has no real significance if the force majeure clause is sought to be invoked. Of course, you could still try to seek relief under the Temporary Measures Act, but if the other party is saying, no, I can't perform, I want to invoke force majeure, then that proceeds in the normal way. You would go to court and you would argue about the force majeure clause, whether it applies, whether it's been appropriately triggered, and so on. So I'm going to pause here and hand over to Eunice, who will take us through the differences, I think, between mediation and arbitration before we come back to this section.
Thanks very much, Colin, for that. So now we kind of switch gears a little bit. Colin has covered your options, right, under the COVID-19 Temporary Measures Act. And now we are looking at, assuming you want to look at other options, as opposed to going to the assessors, right, at the Ministry of Law, what can you do, assuming you have a dispute for a commercial dispute in Singapore? So this slide sets out the three main ways that you can respond. There's arbitration, mediation, and litigation. So I put mediation in the middle, not because I'm a proponent of it, although I am, but because mediation has a close relationship with both arbitration and litigation, and can be used together with both schemes. And you see that I've also set out some of these logos, which many of you will find familiar. And these logos represent the different institutions. So for arbitration in Singapore, for shipping disputes, parties often turn to the SCMA. For general disputes, the SIAC, Singapore International Arbitration Centre. Of course, there is the International Chamber of Commerce, the ICC, the ICDR, and interestingly, the Law Society of Singapore has also started offering an arbitration scheme as well as a mediation scheme. So I've put ICC, ICDR, and Law Society down here because they offer both arbitration and mediation options. For mediation in Singapore, there are two main commercial mediation centers, the SIMC, which focuses on international disputes, and the SMC, which focuses on domestic disputes. And finally, there is litigation, which is going to court, which is often a last resort for many parties because of the publicity and costs that are involved. And of course, in Singapore, you have the Supreme Court, the Singapore International Commercial Court, and the State Courts of Singapore. So this is broadly where you can turn to if you encounter a commercial dispute in Singapore. Tian, I know that you were supposed to introduce me, but I think in the interest of time, I'll just carry on.
Yeah, carry on.
Yeah. Okay. And then just moving on, I'm going to zoom in on mediation because this is my area of expertise and share with you what you really need to know, in my view, about it, especially in these challenging times. So first, to explain mediation. So from the poll, I saw that 71% of you actually thought that mediation was superior to arbitration, or you might prefer mediation to arbitration. But in case some of you may not be so clear the differences, I'll just spend a brief amount of time on that. Mediation is meant to be a very collaborative process where you have a mediator who is that neutral third party. This person is impartial, right, and is trusted by both sides and will come in to try and facilitate a negotiation between both sides. The beauty about the mediation process and the reason why it is often very effective is really the difference that a good mediator makes. Generally, during the mediation itself, I've set out in this slide what happens, right, in terms of on the day of the mediation. But even before that, there's actually a lot of work to be done. And it's very important to prepare for a mediation by choosing the right mediator, the right mediation institution. And that's just the first step, right? And also you have to prepare for what you want to do at a mediation, because mediation, unlike arbitration or going to court, doesn't involve a judge figure telling you what to do. The mediator is there to try and facilitate and encourage you to come up with solutions on your own. So what you get out of mediation is often what you put in, right? So actually preparation is very important. But for those of you who haven't actually participated in a mediation before, this is generally what happens. A mediator will start the session with an opening and then invite each of the different parties to give an opening statement. And this is one of the things that makes it very different from arbitration and litigation, because in those two processes, your lawyers will represent you. Whereas in mediation, it is often, very centered on what the parties want and what they have to say. So they actually communicate directly with the mediator and with each other. Lawyers are often there as well to offer advice and support. And then there is this agenda setting. So the mediator will set a roadmap essentially to guide the discussions. Each of the agenda items will be explored, and then the mediator can use these two tools of private sessions and joint sessions interchangeably. And a private session is kind of a caucus in the mediation where the mediator can speak privately to the parties, or maybe one side, right, without the other side, just to have them be able to share frankly and without any inhibition, right? And whatever is shared in a private session is not conveyed to the other side. So you can imagine a mediator who's skilled in this will be able to kind of discern from these private sessions and joint sessions whether there is a zone of possible agreement, and try and guide parties towards that zone. And eventually the outcome is a settlement. And I must say that for mediation, the settlement rates across the different institutions is generally very high, ranging from between 70 to 80+%. And this quick table is meant to help you kind of decide what kind of process might be suitable for you. So the adversarial refers to the kind of process where you are involved in fighting the other side. So arbitration and litigation are adversarial processes. Amicable processes are like mediation, where you have a mediator, or even negotiations, where you try and resolve the matter on your own without a third-party mediator. So I won't go through the table in detail. Suffice to say, this really is meant to convey to you that there is a place for different dispute resolution mechanisms, right? When you are looking for something low cost that you can complete in a relatively short period of time, right? This will point you towards an amicable type of process like negotiation and mediation. But on the other hand, if you need a monetary award, you need a legal remedy, right? So an example of this is an injunction. Yeah, if you need the court to order an injunction, if you need the court to make some enforcement order, then there is there is some limitation to what mediation can offer there, right? Mediation is a lot about generating a flexible and creative commercial solution, right? So you're not limited to a money compensation. You can think about renegotiating contracts. You can think about future relationships, right? All this is open for discussion at a mediation. So this slide summarizes in a nutshell why you might want to mediate, right? The first is if you want to manage that conflict, right, and try and resolve it. Mediation will allow you to do that in an environment where you can communicate confidentially, effectively, while preserving the business relationship between both parties, as well as save time and cost. These reasons are actually backed up by the experience of the ICC. The ICC has a Center of Alternative Dispute Resolution, or ADR, which oversees the mediation. For last year, ICC has kindly shared some statistics with us. They have 35 mediation requests involving 97 parties from 34 jurisdictions. So you can see that mediation as a tool is something that can be very suitable for international commercial disputes. The ICC mainly sees parties from Europe, as well as Asia and the Pacific. And in the last year, there were actually 2 parties from Singapore involved. And the types of disputes that can be mediated are various. So many people might think mediation is something more for the family disputes or community neighbor disputes. But in reality, it is a very effective tool for construction disputes, engineering disputes, right, IP disputes, and a whole host of other commercial disputes. The value of disputes the ICC sees, you can see the range here. And in contrast, you see the cost of the proceedings is very much more controlled than if you compare it with an arbitration or litigation proceeding. Okay. I also wanted to share with you just a little bit about this survey, because it's a very recent survey done by the Singapore International Dispute Resolution Academy, and it kind of explains why most people choose mediation, right? And these are for impartiality, neutrality, speed, and confidentiality. Enforcement is not often ranked as a reason to mediate, yeah? And parties have observed that when you want to choose a good mediator, you need to look out for good ethics as well as dispute resolution experience. So these are just some tips to share with you when choosing a mediator and choosing mediation. Well, although enforcement hasn't traditionally been a reason to select mediation, because after all, it's amicable, right? So the first point here, voluntary enforcement. This is often what happens after you reach a mediated settlement. But then again, given that commercial disputes can be very different. So it could be a dispute between 2 parties that, don't often have a relationship with each other, don't have a long-term relationship. You might be thinking of enforcement through other ways, and that is where mediation kind of sits in the middle, right? Like I showed you earlier, because you can pair mediation up with arbitration, you can pair it up with court action in order to enforce your mediated settlement agreement. Depending on the questions, I'll say a bit more about these different mechanisms, but I think we'll just move on for now. Okay. Now, the Singapore Convention on Mediation is one of the recent developments that is quite critical to the mediation landscape and to Singapore as well. Some of you might know that in arbitration, there is a convention called the New York Convention, which you can use to enforce your arbitral award in other countries, right? More than 150 countries in the world. For mediation, right, recently we have gotten a convention for mediation that will do a similar thing. So under the framework of this convention, all you need to do is supply your settlement agreement, right, to the enforcing body. It could be a court, right, depending on the country's rules on that. And you show that this settlement was arrived at through a mediation. And then there's a question of whether there's an applicable defense to enforcement. So very similar to the New York Convention framework. And the defenses are generally quite similar as well, save that mediation has two unique defenses that relate to the conduct of the mediator. Yeah. And then if there are no applicable defenses, and as you know with arbitration, the threshold is fairly high, then the competent authority must enforce the settlement agreement. So this convention has been lauded and it has been, the response to it has been very, very positive. So Singapore is one of the first signatories, and we have also since ratified the convention along with 4 other countries. Over 50 countries have already signed this convention, and it will come into force in September this year. The limitation of this convention is that it only applies to international mediation. So you can't use it for domestic mediations, but you don't have to worry about that because in Singapore, we have a separate mediation act that will cover your domestic mediations and allow you to enforce those through the courts very easily. And they only apply to commercial disputes, okay? And they do not apply to settlement agreements arising from the court or arbitration context. And this is because there is a need to maintain some kind of distinction between the different conventions. And as you can see, there is a lot of support for this convention, and I think it speaks to the value of mediation as an effective way of resolving disputes. Usually, mediations are commenced because there is a clause in the contract which contains a reference to mediation. If you go to the website, you will see that the ICC provides various options for a mediation clause. So this can be mediation before arbitration, right? A mediation after arbitration, mediation as an option, not making it obligatory. So ICC has actually thoughtfully put together these various options that you can consider using. So you can refer to this in your own time. And finally, I'll just say a bit about how mediation is taking place in this sort of pandemic environment. The Singapore Supreme Court has actually worked together with the Singapore Mediation Centre on this SG United Mediation Initiative, which provides a free mediation service to selected cases that the court identifies. For the ICC, I understand that most of the mediations are happening online now using the Zoom platform, which is what we're using today. And as Hazel has said, right, the centre has adapted to be able to continue its operations even in this climate. So if you have a mediation to prepare for, right, remember preparation is very, very important, and choose the right mediator and the right mediation institution. Okay, so now I'll turn the time back to Colin, who will wrap up on arbitration before we start answering all those questions that are coming in. Thank you. Colin, over to you.
Thanks very much, Eunice. I'm going to skip over the sort of introductory slides and features of arbitration that I think Eunice has already covered. I'm just going to go straight into some of the specific procedural innovations that the ICC has introduced. One of the complaints that we've heard in recent years about arbitration is that the cost of arbitrations, particularly international commercial arbitrations, has increased, and the speed of resolution of arbitration disputes has become much slower. And those were two of the key advantages that arbitration traditionally was perceived to enjoy over litigation. So to combat this, the ICC, I think, has led the way in introducing a number of tools and devices to try and ensure that arbitrations continue to provide users of arbitration with an expeditious means of dispute resolution. The ICC, as I'm sure all of you know, is one of the world's leading arbitral institutions and enjoys a particularly strong reputation in the international arbitration community. And one of the key features of ICC arbitration is something called the scrutiny process. In other words, the tribunal, before it delivers its award, the award is scrutinized by the Secretariat and the ICC Court to ensure that, or as far as possible, that there's no procedural defect in the award, and to ensure that the award is more likely than not to be enforceable. Can I then just talk a little bit about the rules of arbitration, the ICC rules of arbitration? One of the features I think that will be particularly attractive to this community in particular is the introduction of the expedited procedure by the ICC for cases where disputes, the amount in dispute is less than $2 million US, or if parties agree. There is, unfortunately, because the expedited procedure was only introduced in 2017, by default, the procedure is only applicable to arbitration agreements concluded after 1st March 2017, or parties agree. But this is an excellent service, I think, for the many cases where the sum in dispute is not actually large enough to justify a sort of full-blown, hard-hitting international arbitration with all of the bells and whistles. And what the expedited procedure tries to do for these sorts of cases is streamline the process. So, for instance, even though the arbitration agreement might say there will be a tribunal of 3 arbitrators, each party will appoint 1, and both arbitrators will appoint the presiding arbitrator. Under the expedited procedure, the ICC court may appoint a sole arbitrator, which is very useful, because otherwise the appointment of the 3 arbitrators alone might take months for parties to agree, put forward their nominees, and so on. Similarly, under Article 3 of the expedited procedure, there's no need to draw up terms of reference, which again cuts out a significant amount of delay. The tribunal might impose, or has the power to impose, a guillotine on new claims and conduct documents-only arbitration. So all of this is designed to speed up the process in cases where the amount at stake is not large enough to justify, as I said, all of the additional procedures and costs that typically come along with a contested arbitration. And similarly, in Article 4, there's a very tight deadline for the tribunal to issue its award. Now, finally, can I just talk a little bit about the summary determination procedure as well? Personally, the summary determination procedure is not resorted to very often because most cases that are brought to arbitration, just like most cases that are brought to court, are actually cases that need to be fought out on merits. They're not so obviously unmeritorious or hopeless that they can be determined without a trial or without a hearing. Having said that, every once in a while you do get unmeritorious cases, and similarly, I think a lot of people will try to use the pandemic as an excuse for not performing their obligations, even though on the evidence, the non-performance has got nothing to do with the pandemic. So perhaps those sorts of cases might be suitable for the summary determination process, which the ICC has power under its arbitration rules to put into effect. As I have stated on the slide, Article 22 of the rules is a broad provision which requires the tribunal to ensure an expeditious conduct of the arbitration and provides the tribunal with a wide discretionary case management powers that the tribunal can draw on for this purpose, including the summary disposal of the claim or the defense. Now, I'm conscious that we need to leave time for the number of questions that have come in. So I'm just going to wrap up there and hand the floor back to Yvette and Tian to conduct the question and answer session. Thank you very much, everybody.
Yes, thank you very much, Colin and Eunice, for that very insightful presentation. And we have received a good number of queries from the attendees beforehand. So thank you to everyone who has taken the time to do so. I think this really underscores the specter of disputes in the wake of the COVID-19 pandemic, and underscores that this is a very real and relevant concern in light of the situation today. And in the interest of time, and try as we might, we obviously are not going to be able to cover all these questions, but what we'll seek to do in this segment is to address the more pressing themes and concerns that have come up of these questions. I'm conscious that a number of queries have come in via the Q&A function as well as the raise hand function. But I think perhaps we can start off with a question that we saw from a number of attendees ahead of time. For Eunice, what advice would you give to a GC wanting to use mediation but facing internal resistance on the basis, for example, that mediation is ineffectual, or that the party proposing mediation loses face, or that it's seen as a sign of weakness? And just as a quick follow-on, what if the opposing party does not want to engage in mediation? Can you compel the party to do so?
Thanks, Yvette. So I'll take the first question about how you convince your management or the board to try mediation. And one suggestion I have is to use a risk analysis and a cost-benefit analysis, because I've shared that depending on the institution you go to, you can obtain their statistics, right? But they range generally between 70 to 80+% success rate, yeah? And you consider that against the time, right? You take into consideration the value of the dispute and the likely cost you might incur if you go on to arbitration and going to court. I think that if you do this analysis, often you find that it is worth giving mediation a shot. For the second question, which is, Yvette, what was the second one? It just slipped my mind.
What if the opposing party doesn't want to engage in mediation? Can you force that through?
Okay, so because it's meant to be an amicable process, right? You do need both parties to come to the table. If in your contract you have a mediation clause that requires, right, that it requires mediation, so it's not an option, but you are required to go to mediation, then of course there is that tool that you can use to get the other side down to the mediation. Because if they did go to court or go to arbitration, you can apply to stay those proceedings on the basis that they need to go to mediation first under the contract. But ultimately, because mediation, you need, what you put in is what you get out of it, right? So I think it is good to enlist the help of your mediation institution, right? They can often try and facilitate talks to get the mediation started before embarking on the mediation proper. Yeah.
Thanks very much, Eunice. I think that was a very helpful summary of how to address resistance to mediation. And Colin, perhaps we can turn to you. I think one issue of interest to our attendees is whether or not dispute resolution provisions need relooking in this time. For example, do you think it would be prudent to make specific provision for virtual hearings to take place? For example, Chinese law may require that, and whilst I don't believe anyone here is an expert in that field, what is your take on how we might relook dispute resolution or arbitration clauses in this time?
Thanks very much, Yvette. It's a very interesting question. I think to the extent that the law that will govern the dispute resolution has certain special requirements. So for instance, when you say that Chinese law might not generally recognize virtual hearings in the absence of specific provision, then I think it is very important to have specific contractual language in the arbitration or dispute resolution clause that makes clear that virtual hearings ought to be a possibility. Of course, the extent to which you can actually get that into the contract will be subject to whether your counterparty is prepared to agree and the respective bargaining positions of both parties. Beyond that, however, I'm not sure that dispute resolution clauses in general need to be re-examined so fundamentally, because at the end of the day, they're just the basic purpose of a dispute resolution clause is so that parties are on common ground as to how any disputes arising under or in connection with the contract will be resolved. Will it be by mediation first before arbitration? Will it be by litigation to the exclusion of arbitration and mediation? And that basic purpose of a dispute resolution clause continues to serve its function, even in light of the COVID-19 pandemic. All that I think needs to be done is to tinker around on the edges to make sure that the dispute resolution clauses work as effectively and as properly as they are supposed to.
Thanks, Colin. I think that's a fair point. So virtual hearings are not so novel that they need us to overhaul DR provisions as we typically understand them to be. Eunice, would you have anything just to add quickly from the mediation perspective?
So maybe just to share some tips about these dispute resolution clauses. One trend that we are seeing quite a lot now is the use of a hybrid dispute resolution clause or a stepped dispute resolution clause, where parties are required to go through certain steps. So negotiation first, mediation next, and then arbitration or going to court. And this is one way that people can build in a mechanism for having mediation and these amicable negotiations at least given a shot before going to arbitration or litigation. But of course, you need to be very careful about how you do this, because you don't want to kind of jeopardize your own ability to go to arbitration or litigation or unduly delay it. So if you look online, there are the ICC has sort of a mediation arbitration clause that you can refer to. So do other institutions. So you pick the one that is most suited to you.
Thanks very much to the both of you. We've also got somebody, one of our attendees who's raised the hand, Hong Chuang Nguyen. Perhaps I can invite this question from the person who's raised it. Is Mr. Hong still there? I'm conscious that we've exceeded by a few minutes, so maybe the person is no longer around. But that's okay. Is Mr. Hong still around?
I think he's on mute, but I think it's...
Oh, he's been unmuted already, as I understand it. Okay. But that's okay. Perhaps just a couple of quick questions, because I'm conscious that we've exceeded slightly. So maybe just one or two more questions that's streaming in from the Q&A function that I think might be of interest. And this one is for Colin. Colin, in your presentation, you mentioned force majeure and also the doctrine of frustration. What's the relationship between the two? Are they mutually exclusive, or do they exist alongside each other?
Thanks, Yvette. I think it is fair. Well, it's a complex relationship. I think I've seen a couple of questions where the basic thrust of the question is a force majeure clause and the doctrine of frustration mutually exclusive? And the short answer is that it depends on how the force majeure clause is drafted. So if,
Fair
for
enough.
instance, and this relates, I think, to another question that I've seen, if the force majeure clause specifically excludes a certain type of event from its ambit, so for instance, it contains language that says this clause shall not, or this particular event shall not constitute a force majeure event. That shows that the parties have turned their minds and have contemplated the possibility of that specific event and have agreed that it will not be a force majeure event and it will not trigger the force majeure consequences. In that sort of situation, if that event occurs, I think it will be quite difficult to say that it is a frustrating event because parties have specifically considered it and they have specifically agreed that it will not have whatever consequences the force majeure clause provides for. So it's not uncontemplated. It's not an event that's beyond parties' contemplation. Where it's a bit more complicated is where the force majeure clause doesn't talk about the event at all. So for instance, it doesn't even mention pandemic. There, I think there's more scope for argument. I think one party will certainly try and say that the pandemic is a frustrating event and the doctrine of frustration has not been excluded by the force majeure clause just by virtue of the mere presence of the clause. And the other party will, of course, say, well, we agree all of these events should be force majeure events, and we didn't include the pandemic as a force majeure event. So by implication, it's both excluded as a force majeure event and as a frustrating event. Exactly how that will play out and how that will be decided will, I think, depend on what evidence is before the court or tribunal as to what the parties had in mind when they were negotiating the clause, if there is such evidence, and it will turn, I think, on the specific facts of the case.
Thanks very much, Colin. And I'm conscious that we are close to the end of this webinar. And in the interest of time, perhaps just to wrap this segment off, I can end off by asking both you, Colin and Eunice, to share any final words or observations you might have on any specific tips, tricks, and watch points for virtual hearings, be it mediation or arbitration hearings. Just a quick summary to summarize and end off this segment. That's something that's on everyone's minds these days.
Okay, so I'll start with mediation because after all, you often start with mediation and end with arbitration. Well, I would say that because of the circumstances we now operate in, our experience is that if you want a successful mediation, you have to be prepared to build relationships, and don't forget about that. Even though you are, doing the mediation through an online platform, often the result of the pandemic, the restrictions on our abilities to do things we are used to, has caused a lot of people to be actually very, just to put it bluntly, grumpier than usual. Okay, the usual positivity and enthusiasm is often missing. So I would say, don't let that discourage you. Try and be a force for positivity. Try and when you are in a mediation, the key really is to try and think of possible options in order to solve the situation, right? If it's a payment issue, right? There's ways to work that out. It could be installment plans. It could be payments through other means. You structure your payments such that you pay something upfront, something later. You might even take something in kind, right? So there's really a lot of possibilities. So I think if you want to maximize the chance of a successful mediation, you've got to keep an open mind to these possibilities and really contribute so that your interests are met. Yeah.
Thanks, Eunice. Colin, anything to add there?
Well, I think I agree with Eunice when she said a little earlier that the key to a successful mediation is preparation. Obviously, that's also key to a successful arbitration or litigation, particularly in a virtual setting. I think this year's SIEC Congress is dominated by discussions about virtual hearings and how to make sure that they are conducted successfully and effectively. And sometimes what happens or the ordeal of the hearing process is exacerbated in a virtual setting where witnesses can't find documents or bundles, And a lot of time is wasted because the witness is not, to be fair to the witness, it is presented in an unfamiliar setting. Is not quite sure what he needs to do, what he's supposed to be looking at. And so I think there will need to be a lot more time and attention devoted to preparing witnesses for what they will expect in a virtual arbitration setting. Familiarize them with where electronic bundles are to be found, how to navigate electronic bundles, and all of these things which you sometimes take for granted in a physical hearing. Because there's somebody who can sit next to the witness to point them to the relevant document or the relevant page. Unfortunately, all of that can't be done anymore in a virtual setting. So it may well be that when timelines for hearings are agreed or are being set, an extra 1 to 2 weeks should be built in for all of these preparation purposes.
Okay, thanks very much, Colin and Eunice. That brings me to the end of the Q&A segment, and perhaps I'll just invite Tian to leave us with a few concluding remarks.
Yeah, I think with that, we come to the end of our webinar this afternoon, and we would like to take this opportunity to thank our speakers for taking the time out of their busy schedules to be with us this Friday afternoon, and of course, the audience for joining us today. So we hope that you found this interesting and useful as an overview of the legal implications of the COVID-19 pandemic, as well as the various dispute resolution options available to parties to a commercial dispute in Singapore. And lastly, just before we all sign off, if you have some time, we would really appreciate it if you could fill in a very quick feedback poll, which will be launched on screen very shortly. And have a very lovely Friday afternoon and evening, and enjoy the National Day long weekend, everyone. Thank you very much for joining us this afternoon.